All right, good morning, everyone. My name is Doj Raphael. You're welcome to DDM Morning Show.
Good
The
morning.
trial, all right, the trial of Nnamdi Kanu, a leader of the indigenous people of Biafra, has become one of Nigeria's most intense legal battles. Now, charged with terrorism and treason, Kanu's legal journey has been full of twists, from dismissing his lawyers to filing multitudes of legal motions and suits, including a recent 550 million naira case against the Nigerian Medical Association over a forged medical report. Now, as the court approaches the critical judgment scheduled for November 20, the nation watches with bated breath, eager to understand the legal intricacies and political implications of this high-stakes case. Joining us today to talk about this hot issue is Mr. Emeka Ugwonye, Esquire, legal expert and consultant. His insights, based on his critical stance and deep knowledge, will shed much needed light on the legal maneuvers and what they could mean for Kanu's fate. Mr. Ugwonye, you are most welcome to DDM Morning Show.
Thank you very much.
All right, Mr. Ugwonye, I have observed your social media activity over the past 1 week and noticed that many of your posts pertain to Nnamdi Kanu. You seem to be critically passionate about the IPOB leader, aren't you?
Yes, indeed. The trial of Nnamdi Kanu signifies so much for the country of Nigeria, especially for the people of the Southeast. As you might have known, this case has lasted for 10 years, filled with twists, including issues of rendition, and all related to the crisis going on now in the Southeast, the state of insecurity, the apparent inability of the political elite to control the tide of this IPOB agitation. And ultimately, it boils down to one thing, which faces the world now, that is the outcome of the trial of Nnamdi Kanu. That is going to put a definitive position on what the law says about his activities and how to move forward from this moment. So it's very important. I've been following it, and I'm sure many Nigerians are following it very closely.
All right, one of the most controversial aspects of Nnamdi Kanu's case is his extraordinary rendition from Kenya to Nigeria. The Federal High Court initially justified this rendition, but the Court of Appeal condemned it as illegal and the violation of his rights. The Supreme Court later upheld that. Now, while the rendition was unlawful and violated his rights, the trial itself should proceed. Now, for the sake of our viewers, can you help us understand why such a rendition is considered wrong under whether national or international law, and what specific legal principles or human rights does it violate? And importantly, does this kind of violation provide sufficient grounds to dismiss or squash a criminal trial, or can the trial still fairly continue despite this?
Rendition is the process of moving a suspect, a person suspected of a crime, from one country to another to stand trial. Normally, under international law, this process requires a formal procedure called extradition proceedings, which means you will go to the country, the government of the country, the courts of the country in which the suspect is found, go through their judicial system to request for him to be extradited to the country where either the crime was committed or where he is to stand trial. The judicial process of the host country will examine the request, either grant it or not grant it. Extradition is based on general international law, but also on specific treaty agreements between countries. Nigeria and Kenya have a treaty on extradition. What Nigeria did was they went to Kenya, took Nnamdi without going through the proper extradition procedure. That violated the treaty law, that violated the statutory law in Nigeria, that violated general principle of international law. It is wrong, absolutely. In all the various places where this has been examined, all agreed that extraordinary rendition was wrong. First, it came before the High Court, of Bintanyako, Honorable Bintanyako, she did not see the extradition as a serious problem. And I can understand the mindset of Justice Nyako. Remember, at that time, the view was that Nnamdi jumped bail. So from the point of view of Nyako, he was just being brought back to the court where he had been before he escaped. This was an ongoing case, so the judge didn't read much into it. But the lawyers representing Nnamdi Kanu, particularly Michael Zekome, I have high regard for Michael Zekome. He went to Court of Appeal, and Court of Appeal moved to the opposite direction because you've got the two extremes. One extreme is to think that the rendition had no implication or no consequences whatsoever. The other extreme is to think that everything depended on rendition. So the Court of Appeal took an extreme position and said, because of the rendition, that the Nigerian government would not or had forfeited the right to try Nnamdi Kanu. And the court proceeded to discharge him, Court of Appeal. Then the federal government of Nigeria went for appeal to the Supreme Court. And this is where it became interesting. The Supreme Court took a middle position. The Supreme Court agreed with the Court of Appeals that the rendition was something wrong. It was an unlawful event. And there ought to be consequences for that. But the Supreme Court saw the consequences to be consequences in terms of damages for violation of his rights. So the court said he could indeed enforce his fundamental right and claim damages for rendition. Then the Supreme Court deviated from the Court of Appeal and went back to Nyako's position, which was that he should still stand trial. So the Supreme Court took a middle position. Rendition was wrong and compensable in damages. However, it wasn't sufficient to abort trial. I have done some research on this matter, and I tried to find the legal equivalent with what we call unlawful arrest. And I asked myself this question. If a person was arrested the wrong way, if a suspect was arrested in violation of his fundamental right, would that be sufficient to avoid charging him or to dismiss charges filed against him? And the position is startling. The theory is that the arresting event is different from the charging event. So the mere fact that he was arrested wrongly does not automatically foreclose the possibility of him being charged, with some exceptions. And the exception is this: any evidence obtained in the process of the wrongful arrest will be excluded. For instance, if during the wrongful arrest he had to make a confession, that would be sufficient to exclude the confession as a piece of evidence. So any evidence obtained in the process of wrongful arrest will be excluded. However, if there is independent evidence which was not obtained in the process of arresting him, then the state can still charge him. So the important thing is the ability to separate between the arresting action and the charging action. Then we see that. We also look into the issue of search warrant. If evidence is obtained without a search warrant that was required, does that exclude that evidence automatically? All over the world, the courts have told a middle ground. So that Supreme Court approach seems to be reflective of the global standards, but also it is practical and necessary. A country facing terrorism, serious crime that threatens the state in a fundamental nature, cannot say, hey, because of the wrongful way of capturing the suspect, we are going to ignore the major wrong done to the state. So what if the law enforcement agency colluded with him, did something wrong by renditioning him in the manner they did? Does that foreclose the overriding interest of the Nigerian state to deal with this extreme crime pattern called terrorism? So the Supreme Court is right. Now, let us look at other fora that have looked at this. United Nations Rapporteur looked into it. They condemned the rendition. but they did not say he could not stand trial. They condemned rendition. Also in Kenya, the Kenyan court condemned the rendition and awarded damages, but did not say he should that trial should be aborted. So my position, and which I have expressed on my social media platforms, is there is a universal agreement that rendition was wrong, but it is comparable to a case of unlawful arrest. An error in arresting a person does not automatically affect the need to charge that person.
But is there any practical significance? Can you hear me?
Yes. I
can hear you. Is there any practical? You have
Perfect.
mentioned that a lot of bodies and organizations which have condemned the extraordinary rendition. Is there any practical significance of that condemnation to the favor of Nnamdi Kanu?
Well,
okay, what is it?
First and foremost, it depicts Nigeria as a country with a poor human rights record. It may look as an inconsequential thing, but it's very important, because in all other scenarios where a Nigerian is asserting that his rights have been abused, whether this is an asylum claim, whether this is related to other things, Nigerian perception in human rights index is lowered by that incident. For Nnamdi himself, it entitles him to damages. Interestingly, he had already won a judgment in Abia State, Federal High Court in Abia State, which awarded him 500 million for rendition. So that is what he has, and that's what he should have. We don't think that anywhere in the world, by the way, I don't foresee that terrorism, if there is sufficient independent evidence, will be waived just because there was an error in the arresting process. When they arrested Nnamdi in October 2015, they did not have any case on terrorism against him. Even the treasonable felony they had then was shaky. However, they proceeded with those charges, and the only reason was because they hated the word Biafra. There is this visceral hatred of the word Biafra that when Nigerian government hears it, they are willing to do extreme things. So it was the word Biafra that was annoying them. They filed those charges in order, it was trumped up charges, in order to place him under the control of DSS. If you recall, those initial charges were dismissed in early February 2017 by Justice Nyako, based on the preliminary objection filed. She threw away all the terrorism charges. So that showed you that the whole thing was a very poor handling frame-up. They made the case look as seriously as possible, because otherwise DSS would not have had any involvement in it. Without the treason and terrorism charges, DSS would have had no involvement. It would have been a simple, ordinary police case. So, but they got themselves in it because they had this Biafran phobia, and so they mishandled it. Okay, let us say Nnamdi left Nigeria for a while. Since 2021, when Nnamdi came to Nigeria, they could have tried Nnamdi. This, if you look at it, once trial began under Justice Omotosho, you find that the trial did not last more than 2 months. So there would have been no need to keep this case going on for 10 years. It is corruption on the part of the law enforcement agencies in Nigeria. It is absolute corruption. It is ineptitude of the judiciary, because you can see now that Justice Omotosho wants to just go straight and get this case resolved. That was the same speed was not seen under Justice Nyako. The case was dragging. The prosecution were taking forever to file charges. They brought him into Nigeria in June. Why couldn't they formulate charges immediately? Indeed, in an efficient system, even before he landed in Nigeria, while that plane was taking off from Nairobi, the charges will be ready to be filed the next day. They didn't do that. They dragged it. There could be many reasons for that, but it is a combination of corruption and ineptitude. That is a big problem, and I have criticized Nigerian government because it means, by implication, that we can't try people without spending 10 years. How are you going to use law enforcement and the judicial system to combat terrorism and serious crimes if you spend 10 years trying one person? Minus those days when he was out of the country, that was 2017 to 2021, 5 years. If you take those 5 years off, you still have 5 years that was wasted and shouldn't have been wasted. I think that's a deep concern, really.
Some critics argue that the word terrorism is highly politicized. They argue that people in power use the word terrorism to squash genuine fight for self-determination. And self-determination is a word accepted even in international law. What do you have to say that?
Very well. Yes, terrorism could be politicized, but in the case of Nnamdi Kanu, we have sufficient factual theory of what happened. We have a good record of the activities attributed to IPOB. We have a good idea about the creation of ESN. We have a good idea of the utterances and statements made by Nnamdi Kanu. It is not, whereas it's true that the term terrorism could be politicized and contextualized, but we have sufficient factual, common knowledge information about the activities of IPOB, the incitement. We have the case of Simon Ekpa. Simon Ekpa was just, hold on, let me show you something. Simon Ekpa was convicted by Finland. And that was essentially because of incitement of terrorism. And who is? I'm coming. I'm coming. Hold on, guys. So now,
in the chaos of Nigeria.
Okay. So Simon Ekpa was just he went through his process. Finland convicted him for incitement. You will know that Nnamdi's utterances far exceeded that of Simon. You heard Nnamdi's voice during the NSAS protest. You heard him multiple times. So his case is not based on some theory or some stories by Nigerian government. It is based partly on what is commonly verifiable. Yes, and his own utterances are sufficient. In fact, if you look at the 7-count charges, I know many people will misunderstand this. If you look at the 7-count charges, a 7-count charge preferred against Nnamdi, one thing that will strike you is how weak, how shallow the Nigerian government is. Ordinarily, Nigerian government can formulate 100-count charges against Nnamdi because any utterance, each utterance in itself is a crime, is a count. Each utterance is a count. If you take his broadcasts, you are going to find in more than half of his broadcasts incitement of violence. I was hoping to show you where he was, a broadcast where he was endorsing Simon Ekpa. He said Simon Ekpa was absolutely fantastic, that they were together, they were partners. That is incriminating. So this is not some terrorism charges based on a subjective interpretation. The standards are fairly objective. So when they came up with only 4 terrorism counts, that means that these guys really don't know what they were doing. The prosecution, they don't know what they're doing. Anywhere else, Nnamdi will have at least 50 counts of terrorism-related charges. Okay? Now, saying this is misunderstood by people. They think, oh, I'm against Nnamdi, I'm wishing him ill, I want him to get into trouble. That's not it. I'm dealing with objective reality, facts, events that I have to relate with. Every utterance, including where he was saying, kill soldiers, kill policemen, take their guns, shoot more people. His broadcast where he was saying, if you don't sit at home on Monday, you will die. He even said, I know you guys, you have excuses not to sit at home on Monday. If you try it, just dig your grave. These are extreme utterances. Nowhere in the world will it be tolerated. Not in the countries where these statements were made, not in the countries where these statements are acted upon. So whatever it is, I think there is a valid basis for these allegations. Now, the issue of self-determination, let us address it. If you look at the position of self-determination, you find out first and foremost, there is a distinction between self-determination within a sovereign country, that is internal self-determination, and self-determination in the context of a country being attacked or under control of a foreign authority, okay, like colonial authority. You know, they are different. Self-determination in the sense of secession, taking steps in violation of the laws of a sovereign nation, it is going to be resisted. And by the way, when you look at this secession, if you look at the charge, count one is actually based on secession. That's the treasonable felony. Okay? But he really went beyond that. The establishment of Biafran Security Service, and the whole lot. So, is that self-determination? Now, let me also ask you, when you deal with law enforcement, you have to ask yourself, what if everyone else or more people do what he does? A man woke up out of nowhere, not affiliated to any particular institution or any organization, just emerged, incorporated a company named IPOB. It is a corporate entity registered in the United Kingdom, with him as the owner, and made Biafra his brand, business brand, and began to do all those things. What happens if every other person does it? And in fact, you have to understand the pattern in this game. Owazurike did that, called his own Massa, mobilized the youth, sold them a dummy, violence occurred, a lot of people died. Owazurike settled. He's a wealthy man today. He actually appointed Nnamdi as the director of the Radio Biafra. Nnamdi, a more eloquent and a more, aggressive agitator, saw the unique opportunity of the Radio Biafra. That was actually the voice of Biafra. So he elevated himself, broke away from Wazirike, became even more influential, and nothing happened. Then Ekpa came with his autopilot. You saw where, no, it just can't go on that way. That's not self-determination at all. So, and by the way, in dealing with self-determination, you have to ask yourself, all those changes I wanted, all those things I need changed in the country, all those injustices I perceived, could they be addressed by any existing mechanism? Are there procedures and methods through which we could address them? Now, the Southeast, the so-called Biafra, has 15 senators sitting in the National Assembly and probably more than 30 House of Rep members. There is a process for discussion, to demand political change, to campaign and create awareness. One man cannot just come and listen. By the way, hold on. There is something else I want to share with you. There's something else I want to share with you. So you can understand the gravity of the issues we face in this country. Okay. If you look at this, Obiozor was the leader of Ohaneze Ndị Igbo. I recall a speech Obiozo made, and he made this speech in 2021. Obiozo said, "The greatest affliction of man is insecurity. With insecurity, nothing happens that is positive. Among Igbo, one of the challenges we are faced with is security threats, both within the Igbo zone and within the country as a whole. The Igbo nation is not at war with Nigeria, and we are not intending to go into war or demand a separate existence from Nigeria. So Igbo are not secessionists." He said everybody should stop. Then he went on to say, "Biafra requires mature and experienced handling and not a child's play. Children should stop playing with fire." He went on to say, "Nnamdi Kanu is one of us. He is our son, and he must listen to some of us because he is one of us." Anyway, I'm not particularly blaming Nnamdi for what happened next, but Obiozo was attacked, he was ridiculed, he was threatened by IPOB after these things, and his house was burnt down few months after, less than about 2 months after making this speech. Now, you call that self-determination? Self-determination, I call it a criminal oppression. By the way, you saw what happened in the Palestine. How did Hamas come about? Hamas was not the government of the Palestine. It was the PLO under Arafat. Hamas was a group of hotheads who felt that PLO was not doing well, that they're going to step in, and then stepped in and took over a chunk of Palestine. That was how Hamas began to head Gaza, while PLOs remained in West Bank. Now look at the situation. So it's no, I don't see the self-determination theory people are advancing. It's nonsensical, really. I don't see it in this scenario. I see a bunch of criminal activity led by a group of people, and then getting worse. The emergence of ESN, the violence we have seen in the Southeast, the complete destruction of Imo State, Abia State, the imposition of sit at home that causes the Igbos to lose trillions of money. That's not self-determination. I don't see self-determination in it.
Thank you very much, sir, for the response. I believe you make mention of something that everyone will agree with, that Igbo people are not secessionists. I mean, there is an adage that if you happen to be anywhere in the world and there are no Igbo people there, the place is inhabitable because of the entrepreneurial nature of the Igbo people. However, it's also true that there is a systemic injustice towards southeastern part of Nigeria since after the Nigerian Civil War, and which has exacerbated the tension within Southeast and outside Southeast. How are you suggesting we solve this injustice? Because I believe that peace is not the absence of conflict, but the presence of justice.
I agree with you. There has been systemic injustice in Nigeria. Sometimes I wonder if the Civil War ever ended. There has been marginalization. I have been close enough with Nigerian government to be able to know this. I used to be their lawyer in the United States for almost 10 years. I worked closely with ambassadors, and I worked closely with top government officials. I knew this. However, if you look at history, let us start from 1970. In January 1970, the Igbo land was devastated. Nobody was richer than 20 pounds. The richest people had 20 pounds. It was absolute disaster, ravaged by war, ravaged by plunder, sickness, and death. The Igbos began to progress. Look at where they are today. They control commerce. 95% of a trade fair market in Lagos is run by the Igbos. 95% of Alaba International Market run by the Igbos. 95% of our Spanda motor parts by the Igbos. 70% of hotels, mid-sized hotels in Abuja, owned by Igbos. 70% of private schools in Abuja owned by the Igbos. 95%, indeed 100% of auto spare parts in Katsina State owned by the Igbos. Go anywhere in the computer village, whether it is Lagos Computer Village or Abuja Computer Village, 90% Igbos. Go to Banex Market in Abuja, 90% Igbos. The Igbos are progressing. The question is, at what speed? And the necessity of extreme measures, because IPOB's agitation and method is extreme measure. Is it efficient? Is it likely to solve the problem we are trying to solve? On the contrary, it worsens the problem. The sit at home has been economic tragedy for the Igbos. The transportation sector alone in Igbo land is lost 20%. You see, you have 5 working days in a week, and 1 day is taken out. That is 1 out of 5 is 20%. Now, our children in the East, they needed to be in school 5 days a week to even struggle and measure. Now you put them, give them 4 days. Whereas children in the other parts of the country do not have such reduction in school hour. Businessmen in other parts of the country do not have such reduction. Invariably, IPOB's sit at home has deliberately cut off, at the very least, 20% of the economic GDP of the Igbo land. So I don't see IPOB as a solution to those structural injustices we complain. I see IPOB as exacerbation, a worsening of those injustices. That's why I said that it's going to take the Igbos maybe 50 years to recover from the harm done by IPOB. Because apart from these economic losses, you have to understand that Igbos lost significant trust in Nigeria. Somebody came out there and calls the rest of Nigeria zoo and talks about them in the manner he talked. I don't think that that sort of language will endear the Igbos to their friends and their brothers in the rest of the country. Okay. Also, don't forget the tensions within the Igbo land. Let me give you the tensions. The political elite, the governors, the senators, the House of Rep members, the House of Assembly members are not in IPOB. They were not product of IPOB. IPOB is not a political party. So they're all outside it. So now let me ask you a practical question. Let us say that suddenly Nigeria says, okay, Igbos, fine, go for your country, have your Biafra and go. What do you think will happen at that moment? You think that the governors, the current governors of the Igbo states, who have amassed a lot of wealth, will surrender and allow Nnamdi and IPOB to run Biafra? No, there will be a civil war. There will be a conflict and struggle for power. The real Igbo elite today will not disappear. That's it. Then look at Nnamdi's proposal. I had waited to see if IPOB could actually give us a constitutional proposal. Any piece of paper that says, hey, this is what will become the constitution of the state of Biafra. There is no such thing. As a result, we have no idea what the Biafra was going to look like. We don't know whether it was going to be a democracy or a monarchy with Nnamdi as the king, or some military dictatorship, because sometimes they call him commander, or some sort of equivalent of a North Korean government system because they call him supreme leader, or a theocracy? Is Biafra going to be a theocracy? After all, he calls his members Umuchnek and Umu Elohim, which is a religious reference, and they call him prophet. What would be the rights of minority in Biafra? People like the Ijo people, the Efik people, the Anang people, whom he wants to co-opt into his Biafra. But they're not interested, they're resisting it. If you want to see that, Asare Dokubo will start a civil war against IPOB if you were to give them Biafra today. So it is a mess. The prospects of Biafra in the sense of any specific territorial expression is an impossibility. It's madness. There's nothing like that. We are not close to it in any way. Otherwise, I will ask you now, gentlemen, is Biafra going to be a parliamentary system of government? Is it going to be a federation? Is it going to be a unitary system of government? What will it be? You don't have an idea because Nnamdi has not thought in that direction. And until you still begin to think in that direction, you are not serious about having an independent state.
All right, thank you very much, Mr. Uwonye. You have talked a lot about self-determination. I mean, all of these things are, outside the bounds of legality, because I'm more concerned about the legality of the current process. And let's talk about jurisdiction, because it is a little bit complex. Nnamdi Kanu's case is one of the most complex legal issues I've ever seen in existence. Now, I know that terrorism is more or less an international crime. And with the advent of international law, like the Rome Statute of 1998 that established the ICC, there came this, certain principles that govern the way, international criminal proceedings happen. We have a, nationality principle, protective principles, territorial principles, extraterritorial principles, and the all of them. So Nnamdi Kanu has argued that the alleged crime leveled against him happened in a different country, the United Kingdom. However, opponents of this theory say, no, you started the crime in the UK, but it ended in our country, Nigeria. The effects were felt in Nigeria. So when there is this conflict of, jurisdiction, how do you reconcile it? What country actually has the jurisdiction over Nnamdi Kanu's case?
Any of the countries where he was when he made his broadcasts could have jurisdiction, but also Nigeria could have jurisdiction, which is where we call the impact country. Even without specific statutory provisions, it's already established that when we measure, when we ask where a crime was committed, we have to look at either where the suspect was when he carried out his action, or where the victim of his action was. If you have somebody standing on the Benin Republic side of the border and fires a gun, and the bullet hits somebody in Nigerian side of the border, and they ask you, can Nigeria try the shooter? Absolutely yes. He shot from Benin Republic, but it killed somebody in Nigeria. So Nigeria will have jurisdiction, and Benin Republic will have jurisdiction. And if these two countries deal with it, can you hear me?
I can hear you.
Hello? Okay. So if these two countries, yes, if you have conflict, for instance, let's say Benin Republic arrests this person in the example I gave, and Nigeria says, we want to prosecute him. That creates the two countries trying to argue where he should go. They will probably say he should go to Nigeria because the victim is there. So, but there are certain offenses which are by their very nature transnational. One such thing is incitement. based on spoken word is measured not just at the place where the word was spoken, but also where it was received and where it was intended to be acted upon. He was in UK, just as Eba was in Finland. Remember, Finland had jurisdiction over Eba, but if they had sent him to Nigeria, Nigeria would have had this jurisdiction, based on the same principle of trans-border operation. So he was in UK, sending messages to people in Nigeria, telling them what to do, and they were doing it. If you look at some of the testimonies and the evidence in this Nnamdi's case, there was one man, one of the ESN fighters called Onyami. When they interviewed Onyami, they asked a specific question: who is your leader? Nnamdi. Or whose instructions are you acting? Nnamdi. How did he communicate to you? Through the radio. And then there was a piece where Nnamdi specifically said, go in there, shoot policemen, take their guns, kill them. And then Onyami was specifically asked about an attack at a police station in Imo State, clearly linking his action to the prior instruction by Nnamdi. The instruction was not whispered. It was not sent by text message. It was not done by phone call. It was broadcast. The world heard it. The voice is there. So Nigeria has jurisdiction. Nigeria actually has the best jurisdiction of all the. Kenya would have had jurisdiction to try him because he broadcasted from Kenya. Germany could have tried him. Britain could have tried him. All right. And if you recall, Britain tried one guy called, Gladson or something, okay, for a similar offense and jailed him for 3 years. Okay. Finland tried and jailed him for 6 years. So Britain would have tried Nnamdi. I believe they were in the process. But since Nigeria got him, Nigeria has jurisdiction. But before I go forward, the Nigerian terrorism prevention law specifically defined jurisdiction in a manner that gave it extraterritorial essence. Remember that when it comes to jurisdiction, it's essentially defined by the statute. It is the statute that ascribes these jurisdictions to court, even though it is going to be done consistent with international law. But specifically, the Nigerian Terrorism Act says that it doesn't matter where the person is based when he acts. Whether he is somewhere financing terrorism in Nigeria, he can be tried in Nigeria. Whether he is somewhere inciting terrorism in Nigeria, he could be tried in Nigeria. So that issue has been fairly resolved. I believe Nigeria has jurisdiction to try Nnamdi Kanu.
All right, you have raised another point now that Nnamdi Kanu is also raising. The contention is that the Terrorism Prevention and Prohibition Act of 2013, is a repealed law, vitiated and rendered useless by the new one of 2022. What do you have to say about that?
Well, honestly, I haven't dwelt on this so much. I had decided to resolve it more by presumption. One presumption is that I really doubt that the Nigerian government will prosecute him based on a repealed law. I doubt it. But also, let me indicate that I don't recall the laws in effect at the time. If you noticed, the timeline they cited included things done before 2022. And which law was in effect at that time? It was 2013 law. That was it. I've looked at it. I did not want to dwell too much on that technicality because I knew that he was charged under other laws. The treasonable felony charges was not related to the terrorism, was not Terrorism Act based. So the implication is, in my experience, when you are looking at all these counts emanating from different statutes, even if you succeed in knocking out some of the charges, it does not terminate the trial. You still have a very serious charge that the treasonable felony carries life imprisonment. That's a big deal. But in any event, his objection has been noted by the court, and the court said, all right, we heard you. We're going to address it in judgment. It's going to be part of the judgment the court is going to give. The court has the right to take that approach. The court doesn't want to start deciding these things count by count. It is the discretion of the judge. And for a judge that is pressed under time, given that the case had lasted so many years, the judge just wants to put everything together. Nigerian law allows it. If you look at the trial of the former Chief Justice of Nigeria, Walter Nugget, he raised jurisdictional questions as a preliminary matter. But he was reminded that such preliminary matter will be decided along with the final judgment. It was unfair in the case of Onogen, but at this moment, close to judgment, I think that Justice Omotosho is right in maintaining that all his preliminary objections, challenging jurisdictions, addressing the issue of whether the law was repealed or not, will be addressed in his judgment. And of course, if Nnamdi still persists that he was tried based on a repealed law, that could become a ground for appeal. There is the critical thing, in my opinion, is that all these preliminary objections being raised after he fired his lawyers. Remember, he had lawyers. His lawyers did not raise these things when they were there. He fired them and began to raise these things. I see it as just an attempt to distract the judge and prolong this trial. Otherwise, why not wait and get the judgment in 3 days' time, and then you will know what to do.
Now, what are your thoughts on political solution? You said that Nnamdi Kanu has been putting up, writing to the Supreme Court to stay the proceedings, filing, new charges against the Nigerian Medical Association and all of that, just to prolong, according to you, to prolong his case in order to possibly get a political solution. Now, what does that political solution mean to you? And is it within the bounds of legality?
Well, I had expected, and I even advocated for a political solution. The reason I advocated for a political solution because it was apparent to me that the Nigerian state lacked the capacity to conduct a trial. If you can't try this man, then let him go. Find alternative way to resolve the conflict. And if the judicial solution was not working, then find a political solution. Detaining him just that way was particularly irritating. It was unacceptable. So I had been actually a proponent of a political solution because the judicial solution was not forthcoming. But at this moment, this judge has gone further. The prosecution has closed its case. Remember, what delayed this case all along was that the prosecution could not profile charges and try him. So, if there's any delay at this moment, that delay is coming from Nnamdi Kanu. It's no longer the state delaying. So, I don't think a political solution can come when the judicial solution has advanced as fast as it had done. I believe ultimately that the controversy will end up in some kind of political compromise. Nnamdi will be pardoned. If sentenced, if convicted and sentenced, he'll be pardoned. But that political solution cannot occur at this time. This is the worst time for it to occur because that will mean you are trying to block the judgment. It will be odd, really, because if you have a political solution and pardon Nnamdi, you make it impossible for Nigerians to test their law. You will deny Nigerians the opportunity of knowing finally, definitively, what the position of the law is on this set of activities. It will be unfortunate. Besides, if you pardon Nnamdi today, you're going to deal with the issue of what will be the appropriate conditionalities. You cannot give him unconditional pardon, because unconditional pardon will amount to him going and continuing with IPOB. It will be going to manage ESN. If you recall, in one of his outbursts in the court, he said that once I'm out of here, in 2 minutes, the unknown gunmen will be over. That was actually indicted, self-incriminatory, because how will you be able to do that? How will you be able to stop the unknown gunmen? Do you know them? Do you communicate with them? And with what instrumentality are you going to stop them? Does it mean you have your own private army, or are they working for you? So it was very, very odd. And one problem I have noticed in Nnamdi's case, not just now, from a very long time, is that he is the worst sort of client any lawyer could have. He wants to talk. He has an idea how things should be. And all the lawyers should just follow his idea and say whatever he wants said. That is incredible. Once you will notice that when more senior lawyers like Agabi came into the case, the first thing Agabi did was to reset the button. He had to reset the atmospherics by apologizing to the judge on behalf of Nnamdi, apologize to the court, even though it wasn't Justice Omotosho that Nnamdi had problems with. It was the previous judge, but it was very necessary to set a new tone. He apologized. That was a sign that, hey, I'm in control of my client. Henceforth, we're going to play it by the rules. That was very beautiful because it gets the court to relax and look up to the lawyers to lead the process. But when you have a client that leads the lawyers, it is incredible. That's a nightmare for everybody. So, dealing with these issues, there can't be a political solution at this moment. So the president, Tinubu, was right in saying that he can't do anything or say anything until the case is over. If he does otherwise, it will be interference. It will be a case of lack of independence for the judiciary. You got to let them do their work. They already gone fine to it. Now, Nnamdi's effort to delay this, he's obviously trying to delay this case. Remember, when he fired his lawyers, he said he needed 90 days to prepare for his defense. The judge said, no way, you're not going to have 90 days. Because you can't have 3 times the amount of time it took the prosecution to make the case. He said he had compellable witnesses he was going to call. But if these witnesses were not going to come voluntarily, you will need subpoena power of the court. Court will need to subpoena them. And the court is not going to subpoena anybody until you have demonstrated some indication of the relevance of the testimony you are, like when you say you are calling Malami to testify, what is Malami going to say? Is Malami going to explain your defenses? You want to call Wike? Why are you going to call Wike? All this is going to be political sensationalism, and the judge is going to block all those things. But in any event, he did a sudden about face. Not only did he not call witnesses, he said he's not going to put up defense. And then he began to raise objections that had already been raised. Don't forget that his lawyers already filed a no-case submission. When the prosecution closed their case, his lawyers made all these arguments that have been made, the repealed law, the lack of jurisdiction. The only thing his lawyers couldn't go into was the issue of rendition. And the reason they couldn't go into it was that the experienced lawyers. You're not going to bring rendition back when the Supreme Court had taken a position on the matter. Because Justice Omotosho will never, whatever he thinks, he cannot address the rendition issue when it had already been addressed and finalized by the Supreme Court of the country. So as far as Omotosho is concerned, the issue of rendition is off the table. But all these other issues have been canvassed adequately, and the court had ruled on them. So when he took on his own defense, he still repeated these applications. And guess what? The judge said, all right, I'm going to rule on them in my judgment. Honestly, the judge could have said, no, I discountenance this application because it was already addressed by this court. But the judge is bending over to accommodate Nnamdi. Another thing Nnamdi is trying to do, obviously, from all these things is he is trying to bait the judge into a confrontational exchange, personal exchange, so he will have a basis to ask the judge to recuse himself, just as he did in Yanko. And if the judge recuses himself, then he will buy more time for political negotiation, a political solution. And of course, if this trial is not resolved now, and it comes close to the election time, it's going to be a problem for Tinubu. So these are dynamics. He wrote to the judge, asking the judge to defer judgment date. Judgment was scheduled for the 20th after he was foreclosed. Then he wrote to the judge to defer the date. I'm sure the judge is not going to grant it. Now, he wrote a letter to the Supreme Court, to the Chief Justice of Nigeria. Now, tell me, what is the legal significance of that letter? Zero. Zilch. That letter had no meaning. It's unknown to law. You know why? Because the Supreme Court has no jurisdiction over a case until that case has properly come to it on appeal. You have to understand that even though it's called Supreme Court, its jurisdiction is pretty well defined. Supreme Court assumes jurisdiction over a case after the case has been properly filed before it. And the case cannot be filed before the Supreme Court. This type of case cannot be filed before the Supreme Court until there is a judgment and you have gone through the Court of Appeal. So bypassing the Court of Appeal and going from High Court to the Supreme Court has absolutely no basis. Besides, it wasn't an appeal. They said he wrote a letter to the Chief Justice. There is nothing, the Chief Judge can't even call Justice Omotosho. She can't communicate with the High Court at all because the case is not before the Supreme Court. If Supreme Court intervenes in this case at this moment, it is going to hinder the Supreme Court from handling it if it comes to it properly, because that will operate to bias the Supreme Court towards the case. So Nnamdi is engaged in a wide-scale destructive measures, hoping to find a basis to prolong the trial before Justice Omotosho, prolong it while buying more time for political solution. But I don't think it's gonna work because they crossed that point. The prosecution finished their case. Nnamdi has been foreclosed. So they are now on a straight track leading to judgment. I think Omotosho is writing his judgment furiously. And in 3 days' time, he will probably give that judgment and we know what it is. And that will be the end of the trial in that case. Obviously, there will be appeal, but that's a different matter altogether. It is when Nnamdi has been, assuming he is sentenced and he is in prison, that is when the government can approach, because I'm sure the pressure for his release will continue. I don't understand it. Some people are acting out of fear. All the governors in the Southeast, they don't support him. I know they don't support him, but they are afraid of offending his supporters. He's extremely popular. He has millions of followers. So no politician in his right senses would like to openly antagonize IPOB. But deep down in their hearts, they are deeply concerned about him. They don't want him free. He's going to disrupt a whole lot of things. So if he's going to come out on pardon, they will come with very stringent conditions that he will sign, and then they'll grant him pardon. But certainly he will be out, probably after the 2007 election. He could be, you see, for politicians, if Nnamdi could be a political asset, if releasing him will yield political assets, they will release him. Somebody, if he can work out something and support the government, they will release him. That's one possibility, but it's not guaranteed. The next thing is he will be a legacy project. For instance, if he's released after 2017 elections, Tinubu will not be running again, but then it becomes his legacy, his gift to the Igbos.
You mean 2027 election?
Yes. After 2027 election, if Tinubu comes to power a second term, he's not running for a third term, so he doesn't need to campaign anymore. So whatever he does at that moment will be a legacy project. Presidents, people pursue legacy projects in their second term. In their first term, they pursue re-election as their priority.
All right, briefly now, because we're out of time.
Thank you very much, sir. Yeah.
His judgment is coming up. His judgment is coming up on November 20th. What do you foresee from now? What will happen? If he is convicted, what will happen? If he is acquitted, what will happen?
Well, if he is acquitted, it will create more problem for Nigeria because, you know, it will make a mess of this whole thing. Why did you arrest him? Why did you keep him all this while if in the end you didn't have a case? What is the point? It will make the Nigerian state look very horrible, extremely horrible. And it will hinder their ability to address similar cases in the future. It will be embarrassing. So that's why I think he's going to be convicted. Now, will he be convicted on all the accounts? I don't know. At least I know that count 2. He will not be convicted of count 2. Even if he's convicted of count 2 carries only 1 year imprisonment and he'll get credit for time already served. So it's inconsequential. So he's going to be convicted, especially because he failed to put up a defense. The implication is very startling. The prosecution put up a case. You filed a no-case submission suggesting that they did not make a prima facie case against you, that they had no evidence, that there's nothing in their case, that it's not even worth responding to. And the judge said, no, there is something to answer. There are things you need to controvert. There are things you need to challenge. When he failed to challenge that, don't you understand the implication? You see, one thing people don't know is judges are guided by certain principles and procedures in their rationalizing process. In giving the opinion judgment, judges are guided by evidence. The prosecution came and brought evidence to prove their case. You did not bring any evidence to contradict it. You did not call witnesses to explain anything. You really did say nothing. Now, in terms of the judge, what is the judge looking at? The judge is looking at the evidence presented to him, which went unchallenged. On what basis will Justice Omotosho reject the evidence of the prosecution? On what basis? It wasn't contradicted at all. Absolutely. Initially, I thought that Nnamdi's reason for taking on his defense was to muddy up the process. In other words, I know I'm going to lose this case in this court, but I want my people out there to continue to see me as a hero. I want to take steps that will deny the judgment full legitimacy. Because you know what? If he didn't defend himself, if he had no lawyer, people will continue to wonder, oh my God, if only he had a lawyer. Oh, if only he had a chance to provide it. That's why the judge was startled when he fired his lawyers and chose to defend himself. It's like, what? Because defense lawyers are important. They help legitimize the process because they help suggest that the accused person received trial, was effectively defended and represented. When he is not represented, people will imagine things, and Nigerians are prone to imagining things. You can see the debates on social media. It is very intense. People are attacking me, criticizing me. They don't understand things like jurisdiction. They don't understand the process. I mean, people still say to me, oh, why didn't the judge read it to him when he told the judge to read the law? I said, how could the judge read the law? You chose to represent yourself. So the judge is not going to become your lawyer explaining anything to you. Besides, you asked that question in a confrontational manner. You told the judge he had no jurisdiction. Let him read that for you. The judge said he's going to rule on this matter later. You want him to give an opinion now. The judge will remain mute because whatever he says now, he's going to get into trouble. If he takes a position now and later in his judgment repeats that same position, somebody will say, oh, you already made up your mind. Last week, that was what you said. And now you're writing the same thing. You made up your mind even before judgment. So he was baiting the judge, dragging the judge into a confrontation, and the judge was extremely careful, well prepared for this judgment, for this case. The judge did not do anything. Otherwise, if you do these things before judges, they will take drastic measures against you. No litigant is allowed to confront the judge in the manner Nnamdi has done. But you know why. They're managing this crisis to see if they can just go through it before another judge will be asked to recuse himself.
Thank you very much, sir. Before we wrapped up, do you think Nigeria is handling the Nnamdi Kanu question in a way that leads to long-term peace, or are we simply postponing a larger national crisis, considering the fact that he is popular today, not just in southeastern part of Nigeria, but across Nigeria?
Very good question. Nigeria is the biggest blunderer. I know. Nigerian government blundered throughout. They mishandled this case in so many ways, not just with rendition, okay, in every manner. They mishandled it. They messed it up big time. And their poor handling of the case had lent credibility, strength to Kanu's contention. It is a very terrible thing. They mishandled it, but the alternative of not doing something is not possible. It's not possible to leave the situation as it is. It has to be addressed. But honestly, the Attorney General, all these people involved in all these things, all this why ought to have been fired long time ago. They're incompetent. Okay, the DSS is incompetent. Look at the DSS allowed him to go to the Supreme Court to go and file something, and people are hailing him. What the heck? The fact that you're representing yourself now does not mean you have all the rights a defense lawyer would have. Okay, because the reason they allowed him to go to the Supreme Court was he said, well, you know, I'm representing myself. I don't have a lawyer, so I have to go. That was absolutely ridiculous. Okay, what if he tells them, okay, now I need an internet, I need laptop and internet here because I'm drafting and researching my case law. Would they give it to him? No. So there is incompetence, but it's still better to start the healing process. You know, the incompetency in the government will be reflected in the pardon. Remember, the reason for pardon, more or less, is an admission that this is not just an ordinary case. There is a lot more to it. So I believe that the political process will be used to cure the incompetence of Nigerian state. Otherwise, if they had clean case, well prepared, and you go to court, prosecute, and get a judgment, who is talking of pardon? You go and stay there. This pardon is going to be the need to compensate for the blunders. And that's also a way to assuage the feelings of his supporters. Because with the sort of support he has, if you leave him in prison, you make him a hero. It was actually Nigerian government that made Nnamdi Kanu a hero. Absolutely. When they arrested him in 2015 and began to bring all this Biafra thing, people then recognized him as the Biafran face. Since the government has personified Biafra in him, people followed the government and personified Biafra. So it's a big blunder. I hope there is a solution, but that healing process, one way or the other, will start after the judgment is entered. And now, will he be acquitted? We never say never. One thing I know is that, especially when we are dealing with a case pending in court, you don't want to speak in absolute terms, because when you do, that is what creates this prejudice that suggests that the judge is wrong. No, all I can tell you is that the judge knows better. He knows this case better than us. He has studied the evidence carefully. So he is going to be in a position to determine what it will be. But if the court acquits him, it will be a disaster worse than conviction. Let me tell you something. If you can convict Nnamdi and pardon him, the only way you can do and don't do is if you convict him. If you acquit him, you cannot reconvict him. If you acquit him, you have destroyed the basis for dialogue. You have destroyed the basis to compel him to a table to talk with you. Why would he talk with you when he's innocent and clean? There's no reason. So I doubt that he will be acquitted. He has to be convicted.
Thank you. Yeah.
For the hearing to start.
Right, we appreciate your contribution.
Thank you very much, sir, for joining us. We run out of time.
Thank you. Thank you so much.
Mr. Tuchukurafe, we can continue.
All right, we appreciate your contribution, sir. We believe that before the November 20th comes to us, there might be another court or legal drama from Canada. We always have you to expatiate.
I expect that he will file something today or on Tuesday. And what will he do today on Tuesday? He will likely tell the court that he wants to present a defense. He's going to do that. I'm expecting him to do that. Everything can be tried to avoid judgment on Thursday. But I think if he says so, the judge will say, no, you have been foreclosed. We have to close this case. Thank you so much, gentlemen.
Okay. All right.